The city's ready to proceed at this point? Okay. Ladies and gentlemen, we call this meeting to order. My name is Richard Geller, and I'm a special magistrate for the City of Cape Canaveral. I'm here by special appointment of the City Council to hear code enforcement cases pursuant to Article 6 of the City Code and also Florida Statutes Chapter 162. This is a quasi-judicial evidentiary proceeding. The burden of proof is upon the city to show by a preponderance of the evidence that a code in violation exists. In other words, I will determine, based upon the evidence presented to me, whether it is more likely than not that a violation has occurred. The alleged violator, the responding party, will have an opportunity to submit any rebuttal or exculpatory evidence, including any testimony. At my discretion, I may allow any member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party. Anyone who would like to testify should sign the sign-in sheet, which I understand is at the podium at the front. Upon request, a responding party may ask relevant and material questions of any city witness, and the city may ask relevant and material questions of any witness for any responding party. I may exclude evidence that I deem to be irrelevant, immaterial, or repetitious. If I determine that a code violation has occurred, I may issue an order requiring that the violator take whatever steps are necessary to bring the violation into compliance. I may require compliance within a certain finite period of time, after which a fine will be assessed. In determining the amount of any fine, I will consider the gravity of the violation, any actions taken by the responding party to correct the violation, and any previous violations by the responding party. Under the City Code and the Florida Statutes, I may assess and order the payment of a fine of up to $250 per day for a first violation and up to $500 per day for a repeat violation, as well as the cost of any repairs made by the city. At the conclusion of the hearing, I will issue findings of fact and conclusions of law based on the evidence of record, and will thereafter issue an order both here on the bench and in writing. The city may record a certified copy of an order imposing a fine, which will become a lien against the property where the violation occurred, as well as any other real property or personal property owned by the responding party. Any order I issue may be appealed to the Circuit Court for Brevard County, Florida, within 30 days. It is the responsible of the appealing party to obtain a record of these proceedings. An appeal would be limited to the record that is presented to me. So at this point, because the city attorney is not here, I'm going to ask anyone who may testify, either for a responding party or any of the city code enforcement officials, to please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you. Just some preliminary administrative business. The next meeting, hearing before me will be on March 24th, 2020. And then also, I understand that the minutes of the September 19th, 2019 Code Enforcement Board have been approved. That they were, that is not before me since I was not present there. So we're going to call the first case, which is case number 2019-340, a violation of section 94-121D, non-conforming signs, City of Cape Canaveral, Code of Ordinances, the address 7090 North Atlantic Avenue. The property owner identified as Michael M. Notary, N-O-T-A-R-Y. You may proceed.
Yes, sir. Thank you. The violation is for non-conforming sign, section 94-121D, non-conforming signs of the City of Cape Canaveral Code of Ordinances. The notification summary, notice of violation was sent out on 6/19 of 2019 with a return receipt of 6/29/2019 to Michael Notary, property owner. Notice of hearing was hand delivered in accordance with Florida Statute 162.12 notices to Michael Notary, property owner. A notice of hearing was also sent certified mail, return receipt requested on 2/12/2020 in accordance with Florida Statute 162.12 notices to Michael Notary. This is the property that's in question. It's right along A1A. On September 16th of 2014, City Council revised the city sign code ordinance to address nonconforming signs within the city. Section 94-121 of the ordinance states all signs or outdoor displays which were lawfully erected but do not conform to the ordinance will be considered nonconforming signs. The intent is to phase out nonconforming signs as expeditiously and fairly as possible. And that's the article there for you, Section 94-121. That's the complete article. On December 2nd of 2015, letters were sent out to property owners outlining the types of nonconformities which were to be corrected. By September 16th of 2016, I also have a copy of that letter I'd like to submit.
Thank you.
Excuse me. The city code defines a pole sign as a sign that is supported by one or more exposed vertical supports of any shape which are comprised of steel or other corrosive alloys. It also gives two examples as shown on the screen. The city code defines a pylon sign as a sign that is supported by one or more exposed vertical supports which are encased within a single non-corrosive decorative cover. Non-corrosive decorative cover shall mean any material suitable for installation as a pole sign cover in accordance with industry standards of material and workmanship applied over and attached to the supporting poles, including all attachments and fasteners, which shall contain no steel or other corrosive alloys. And then it gives the dimensions and stuff for the poles, for the cover itself, which in the code it actually states, minimum width of not less than 1 1/2 times the depth of the cabinet, but not less than 12 inches, and maximum depth equal to the depth of the sign cabinet. This is the sign as it looks today. This is the sign we're talking about. Staff has spoken to the property owner. We've spoken to him twice. Well, actually, I take that back. We've spoken to him numerous times, but in the recent couple days, we've spoken to him twice. We spoke to him on the 24th. He informed us that he has somebody that's going to be repairing the sign. I informed him he had to have a permit to do that, so he had his sign company contact me. I then responded to a sign company and told them that they had to apply for a permit and obtain a permit before they did any work. And I actually sent him over to the building official so that he could talk to the building official about everything that needs to be done with the engineering and everything to that effect. So he is aware. He does know we were coming in front of you today. I did explain everything to him. He's already submitted one application that's incomplete. So,
For a permit?
No, I'm sorry. He has not. No, I'm sorry. I take that back. He has not submitted the application yet. He stated that he would have the application submitted. And Mr. Notary is not here today. Would you like my recommendation?
What is your recommendation, sir?
Based on testimony and evidence submitted at this hearing, staff respectfully requests the magistrate find the respondents in violation as set forth in the notice of violation and give the respondent until March 17, 2020 to apply for and obtain a permit to bring the property into compliance, or a fine be imposed in the amount of $100 for the first day and $50 every day thereafter until compliance is confirmed by the code enforcement officer and all costs associated with the enforcement of the violation be imposed.
Also, sir, and my negligence, could you please state your name and your position for the record?
Sure. It's Brian Palmer. I'm the Senior Code Enforcement Officer.
Very good. Thank you, Mr. Palmer. You say that Mr. Notary is not present. Is there anyone here who wishes to appear on behalf of Mr. Notary or has any evidence on behalf of Mr. Notary? Seeing none, let me ask a couple questions of the city. Mr. Palmer, was the prohibition on pole signs and their replacement with pylon signs intended to improve the aesthetics of the city?
Yes, sir.
Okay. And was there a determination made by the city council that 2 years in which to replace pole signs with pylon signs would be a fair and reasonable amount of time to do so?
Yes, sir.
And based on your experience with the Community Development Department, how much time does it take to change out a sign, from the moment that a permit is pulled to, do you have any experience or can give me an estimate?
It takes approximately, if the permit application is submitted correctly with all the proper paperwork, with the engineering and everything to the sign, it takes approximately no more than a month to get the permit actually issued. Once the permit's issued, all permits are valid for 6 months. So they have 6 months to repair the sign once that happens.
Okay.
And in a month issuing a permit is that's the max. It normally doesn't take a month to issue a permit for a sign.
And then once a permit is issued, does the property owner need a certain amount of time to fabricate a new sign, or at least the exterior around where the pole is? Mm-hmm. And do you have any estimate what a fair amount of time for that is?
To actually repair the sign?
Yes.
The permit is good for 6 months, so he would have 6 months to repair the sign.
I understand he has 6 months to repair the sign. I'm just trying to get a sense of if I'm in the shoes of the property owner and I now have my permit and I hand it to the sign company, or let's say the sign company now has the permit. What's a reasonable amount of time for them to take to actually change out the sign? Is this just a matter of weeks or days? Can you give me some sense?
I have one sign company that works throughout the city that has done it in a week. I have some sign companies in the city that's taken them 3 months to do it.
Okay.
So it depends on which sign company we work with and their ability because of their case or their workload or whatever.
Okay.
They have been making priorities for us because of the city council ruling, and because the city council ruling was quite a bit ago, and we've pushed this out as far as,
It's been 5 years.
Yes.
It's been 5 years. The letter that you presented, dated December 2nd, 2015, from Mike German, is that how he pronounces his last name?
Yes, sir, that's the building official.
Okay, the building official. And does the city have, able to provide some kind of evidence that this letter actually went to Mr. Notary? Would it be?
No, sir. No, sir. The letters were not sent out. It was a completely different individual. The letters weren't sent out with the signed received anything. They were sent out just regular at the onslaught. So.
Okay. So what I'm trying to understand is were these letters placed into the mail to all property owners who had non-conforming signs, including Mr. Notary?
Yes.
Okay. All right. So if it's put in the mail, we'll presume that it's received.
Yes, sir.
Okay. Thank you, sir. All right. So I'm gonna make some rulings here, and that we'll put into a written order later, and I want you to feel free to jump in to assist me if it appears I need some assistance. I'm going to make the following findings of fact: that the respondent, Michael M. Notary, is the owner of 7090 North Atlantic Avenue, Cape Canaveral, Florida, 32920, which I'll call the subject property. That on September 16, 2014, the Cape Canaveral City Council revised the city's sign code to prohibit pole signs. Section 94-121 states that all signs or outdoor displays which were lawfully erected but no longer conforming to the code will be considered non-conforming signs. The intent was to phase out non-conforming signs in a fair and reasonable manner, giving property owners 2 years in which to comply. On December 2nd, 2015, the city sent the owners of property with non-conforming signs, including the respondent, Mr. Notary, a letter outlining the nonconformity with instructions to correct the nonconformity by September 16, 2016. Specifically, the city required and requested the respondent to either replace or to retrofit his pole sign with a pylon sign. All sign replacements and conversions require a permit that is duly issued by the city's Community Development Department. As of today's date, this hearing, the respondent has not applied for, and the city has not issued any permit to replace or convert the respondent's pole sign to a pylon sign. He must either remove the sign or replace or convert the sign on the subject property in order to comply with the code. Did I also see, and if I could just interrupt myself, did I also see in the written materials that there was a replacement of the sign face without a permit?
Yes, sir, there was.
Okay. Would a new permit issued, could that be retroactive to cover that prior change of the sign face?
Yes, sir, and that's what we were going to do. That was the intent.
Very good. So that'll be one of my findings. Also, that a code enforcement officer observed during a site visit that a new sign face was installed without a permit. For conclusions of law, I conclude that the city served the respondent with a notice of violation via certified mail, which he in fact signed for on June 24th, 2019, as indicated in the materials for this evening. Mr. Palmer, Senior Code Enforcement Officer, hand-delivered a notice of hearing to Mr. Notary on February 12th, 2020. And also, the notice of hearing was posted at City Hall, also on February 12th, 2020. So therefore, I find that the notice complied with Section 2-253 of the City Code and also Florida Statutes Section 162.06 and 162.12. I find, as a matter of law, that the city lawfully enacted its sign regulations in a narrowly tailored, content-neutral manner to improve the city's aesthetics, which I find to be a legitimate government interest. I find also that the city lawfully amortized non-conforming signs within its jurisdiction. As the ordinance is applied, the respondent has had more than 5 years from its enactment to either replace or to retrofit the non-conforming pole sign on the subject property, but failed to do so. I find that there was a violation of Section 94-121D, non-conforming signs, on the subject property. I find that the city provided the respondent with a reasonable time exceeding 5 years in which to correct the violation, and that it was not corrected. And so the following order will be issued: that the respondent has until March 17, 2020 to either remove the sign or to apply for and obtain a permit to change out the pole sign or to retrofit it so that it is a pylon sign. And that the respondent, Mr. Notary, is instructed to contact the city's Community Development Department to take care of that permit application. If the respondent fails to correct the violation within the time period that I'm setting forth this evening, I would ask that Mr. Palmer or another code enforcement officer schedule a compliance hearing before me, and to duly give notice to Mr. Notary in accordance with law so that he has an opportunity to appear and present testimony and evidence as to whether the violation is continuing on the subject property. Upon a finding by me that the subject property remains in violation, a fine will be entered in an amount up to, it was 100 days for the first, $100 for the first day, and $50 for each additional day until compliance.
Yes, sir.
Okay. The respondent shall be responsible for providing notice to the City Code Enforcement Division of the Community Development Department that he has either removed the pole sign or has taken steps to correct the violation. If we have confirmation that the pole sign has been removed or replaced or retrofitted, that I would ask the code enforcement officer to file an affidavit of compliance. If there is not timely compliance, to notify the city clerk for code enforcement proceedings to schedule the matter for the next available hearing before me, to make a final determination whether compliance has occurred, and if not, if it hasn't occurred, to impose fines. Those fines may become a lien on the subject property and upon any real or personal property of the violator in favor of the city, pursuant to both the city code and the Florida statutes. And any non-homestead real property subject to a code enforcement lien is also subject to foreclosure under the Florida statutes. And the city would also have an opportunity to obtain an award of its costs, including a reasonable attorney's fee, if you were to go, if matters were to proceed that far. Mr. Palmer, is there anything that I've left out?
No, sir.
All right, very good. So we'll call that hearing concluded. And let's move on to the next case. Case number 2019-343, and it's about an alleged violation of section 94-121, non-conforming signs. It's the same provision that we were covering previously. And this concerns the address of 7099 North Atlantic Avenue, Boston Realty Corporation, in care of its registered agent, Jim Morris. Mr. Palmer, are you going to present this as well?
Yes, sir.
All right, you may proceed.
So the violation, again, is for section 94-121, non-conforming signs. The notification summary, notice of violation was sent on 6/19 of 2019 with the return receipt of 6/29/2019 to Boston Realty Corp., care of Jim Morris, registered agent. Notice of hearing was sent on 2/12/2020. I'm sorry, it was hand-delivered on 2/12/2020 in accordance with Florida Statute 162.12 notices. And it was also sent certified mail that same day in accordance with the Florida Statute 162.12 notices to Mr. Morris, registered agent. This is the property in question, just along A1A. Once again, this is the Article 4, non-conforming signs, Section 94-121, non-conforming signs. On September 16th, we just went over this. The City Council revised the City Code ordinance to address these non-conforming signs and to have them, the pole signs to be replaced or removed. This is again the letter that was sent out on December 2nd of 2015. And this is the, by definition in the city code, what a pole sign is. And this is a definition and diagram of a pylon sign. This property has 3 separate signs, and this is how they appear today. This is, I labeled this sign number 1. This is sign number 2. And this is the third sign. On 2/21 of 2020, Barry Signs submitted a permit application to install a pole cover to bring one of the signs into compliance. Staff contacted Barry Signs inquiring about the remaining 2 signs and informed them they needed to have engineering on the pole covers. When they submitted the application, they didn't have any engineering on it, and the building official requires that.
And so there was no engineering on the one permit?
On the one permit that they did apply for. Then on the 24th, the property owner contacted us and informed me that he would have his sign company contact us again about the other 2 signs and about the engineering and everything. So Barry Signs made contact with me on the 24th, sent me a bunch of information on what the sign was going to entail and everything, and that they would be applying for a permit for the other 2 signs so they could have all 3 of them done. They also made contact with the building official, who informed them that they needed engineering on that sign. So they're a little bit further ahead than our last case. They're actually got the ball rolling a little bit more. And I do not see Mr. Morris here either, so. Staff recommends that based on the testimony and evidence submitted at this hearing, staff respectfully requests the magistrate find the respondents in violation as set forth in the notice of violation, give the respondents until March 17, 2020 to apply for and obtain a permit to bring the property into compliance, or a fine be imposed in the amount of $100 for the first day and $50 every day thereafter until compliance is confirmed by the code enforcement officer, and all costs associated with the enforcement of the violation be imposed.
You stated that you do not see Mr. Morris here. Is anyone here to testify or to give any evidence on behalf of the owner, Boston Realty Corporation? Seeing no one here, I will go ahead and issue a ruling. A lot of this will be repetitious of what I stated on the previous case, but we need to have a complete record, so we would ask everyone to please bear with me. Based upon the evidence and the testimony presented at this hearing, I find that the respondent, Boston Realty Corporation, in care of its registered agent, Jim Morris, is the owner of that certain property located at 7099 North Atlantic Avenue, Cape Canaveral 32920. I find that on September 16, 2014, the City Council revised the city's sign code to prohibit pole signs. Section 94-121 states that all signs or outdoor displays which were lawfully erected but no longer conforming to the code would be considered non-conforming signs. The intent was to phase out non-conforming signs in a fair and reasonable manner, giving property owners 2 years in which to comply. I also find that the intent was to improve the aesthetics of the community. On December 2nd, 2015, the city sent all property owners with non-conforming signs, including the respondent, Boston Property Corporation, a letter outlining the non-conformity to correct by September 16, 2016. Specifically, the city required the respondent to either replace or to retrofit its pole sign with a pylon sign. All sign replacements or conversions require a permit duly issued by the city's Community Development Department. As of this hearing, the respondent applied for, submitted an application for one sign which was incomplete for lack of engineering, and then has not yet submitted an application for a permit on the two other signs. So there are three signs that must be either removed or replaced or retrofitted in all. The respondent must either remove, replace, or convert all three pole signs on the subject property in order to comply with the code. The city served the respondent with a notice of violation via certified mail, which was signed for as received on June 21st, 2019. Brian Palmer, the senior code enforcement officer who is presenting this evening for the city, hand-delivered the notice of hearing to the respondent on February the 12th, 2020, and this notice was posted at City Hall also on February 12th, 2020. Notice of the hearing, therefore, complied with Section 2-253 of the City Code and Florida Statutes, Sections 162.06 and 162.12. The city lawfully enacted its sign regulations in a narrowly tailored, content-neutral manner to improve the city's aesthetics, which I find to be a legitimate government interest. The city lawfully amortized non-conforming signs within its jurisdiction. As applied, the respondent, Boston Property Corporation, had more than 5 years from the enactment of the ordinance in which to either replace or retrofit its non-conforming pole signs on the subject property. So I find that there is, in fact, a violation of 94-121D, non-conforming signs of the City of Cape Canaveral Code of Ordinances. I find that the city provided the respondent with a reasonable time exceeding 5 years from the sign ordinance's enactment in which to correct the violation, but that the respondent failed to correct the violation, both within the reasonable time period provided by the ordinance and by the notice of violation. Now I'm going to issue the following order: that the respondent has until March 17, 2020, in which to correct the violation of the city code on the subject property as pertains to all three signs. That the respondent is instructed to either remove the three pole signs or to apply or to submit complete applications for permits to either replace or convert all three pole signs into pylon signs. If the respondent fails to correct the violation within the time period set forth this evening, I would ask Mr. Palmer or another code enforcement officer to schedule a compliance hearing before me and to duly notify the respondent in accordance with law in order to provide the company with an opportunity to appear and present testimony and evidence as to whether the violation is continuing on the subject property. Upon a finding that the subject property remains in violation, a fine will be entered for $100 for the first day and $50 for each day thereafter for each day that the subject property remains in violation. And it is incumbent upon the respondent, Boston Property, to provide notice to the City Code Enforcement Division of the Community Development Department that it has either removed the three pole signs or applied for a permit to correct the violation. If there's confirmation that the pole signs, all three of them, have either been removed or have been replaced or retrofitted with a pylon sign, then I would ask the code enforcement officer for an affidavit of compliance. If there is no timely compliance, I would ask the code enforcement officer to please notify the city clerk for code enforcement proceedings to schedule the matter for the next available hearing before me to make a final determination whether compliance has occurred, and if compliance has not occurred, to impose fines, which may become a lien on the subject property and upon any other real or personal property of the violator pursuant to the city code and the Florida statutes. any non-homestead real property subject to a code enforcement lien is also subject to foreclosure pursuant to the Florida statutes, and the city may obtain an award of its costs, including a reasonable attorney's fee pursuant to the Florida statutes. And I would add that the costs of enforcement were also requested, together with $100 for the first day and $50 thereafter. So I would add that as well. The cost of enforcement would be part of any fines that would be imposed upon a finding of a continuing violation.
Okay, thank you, sir.
Okay, thank you. We'll now move to the third item on our agenda this evening. This is case number 2019-415. The alleged violations are of Section 34-96B and D, standards established by the Cape Canaveral Code and Ordinances, Section 34-98, 4, which involves building appearance and maintenance, Section 34-121, which goes to the intent of these sections, 34-122, prohibiting public nuisances, Section 334-181, A, B, 1, 2, and 3, regarding the storing and parking or leaving of motor vehicles on private property. This involves property located at 380 Harbor Drive, and the property owners are shown as Frank Kizis and Mary C. Kizis. And would you please state your name and position for the record?
Yes, sir. I'm Chris Robinson, Code Enforcement Officer. And this is for property maintenance and an abandoned vehicle at 380 Harbor Drive. Notification of summary. Notice of violation was sent out on 10/22/2019. The letter was returned to sender, and on 11/26/2019, the property was posted in accordance with Florida Statute 162.12 and posted at the City Hall. The notice of hearing was sent on January 4th, 2019. That letter also was returned to the sender. The property was posted 2/4/2020 and was also posted at City Hall.
Correct the dates. It should be 2020.
I'm sorry, 1/4/2020, not 1/4/2019. This is the property right
I'm
here.
sorry, could I make sure I have the dates correct? What is the error in the dates?
January 4th, 2019 should be January 4th, 2020 of the notice of
Oh,
hearing.
I see. Oh, okay. So January 4th, 2020. Thank you.
Again, here is the property on Harbor Drive and Harbor Heights in the north portion of the city of Cape Canaveral. This photograph is the photograph of the inoperable vehicle. You can see that it has a flat tire, and on a later photo, I'll show you that it has an expired license plate. On October 5th, staff sent a courtesy letter to Frank and Mary Kizis about the red Nissan truck in an inoperable condition, flat tire, and expired registration. On October 6th through the 20th,
I'm sorry,
2019.
can I interrupt you? What was the date of the courtesy letter?
Courtesy letter was sent on October 5th, 2019.
Thank you.
On October 6th through the 20th of 2019, several site visits have revealed no change with the truck. Staff also observed the lawn has become overgrown with grass and weeds, and softening is falling down above the front door. I believe you can see the softening just above the roof of the pickup truck there. That's collapsing. That's where the front door is. This is a photo taken showing the yard and how overgrown it is. This is another photograph depicting that.
Did you make any determination how high the grass and the weeds have grown to?
It was well over 6 inches, which is
Okay.
what the code states.
You.
This is my posting for the notice of violation. November 26th, 2019, the notice of violation was returned to the sender. Staff posted the property and displayed a copy at City Hall. On November 27th, 2019 through January 13th, 2020, tall grass and weeds have been mowed sometime during this time frame. However, the other violations remain. The vehicle still remained and the soffitting falling down still remained.
So is the yard now below 6 inches as of today?
Yes, I've got some more photographs that I took today showing that the yard is in compliance.
Okay.
This is my posting of notice of hearing, which on February 4th, the notice of hearing was returned to the sender, and the property was posted and displayed at City Hall. On February 20th, 2020, I spoke with the daughter of the owner who advised she had recently taken ownership of the property since her father, Frank Kaziz, is deceased. And she was just made aware of these code violations.
Was the daughter over the age of 18?
Yes. I explained the process to her and what the corrections needed to be done. Here's the license plate depicting that it was expired.
It expired on 4/19, April
Yes.
2019.
Yes, sir.
Thank you.
On February 24th, 2020, the owner has removed the inoperable truck, mowed and trimmed the property, and a permit application for the roof and soffitting was submitted on February 20th, 2020. So she said, I checked, and she's only submitted a permit application for the roof. She has not submitted it for the soffitting yet. I didn't cite her for the roof. So the soffitting has not. But I had spoke to her, and she assured me that that would be taken care of.
Okay, if I could just stop you. So the application is to what? To replace the roof, replace the
Yes,
shingles,
sir. We're
whatever
going to
shingles?
replace the entire roof.
Okay.
That doesn't include the soffitting.
not-
That'll be separate. And
And
she said
then-
she's looking for a contractor to do that.
Very good. And then and here's a picture of the property where I don't see the inoperable vehicle that has now been removed.
The vehicle is gone. You can notice that the bushes in the front have been trimmed up. The grass has been mowed. The soffitting there is still hanging down.
Okay.
These were taken today. Here's another picture showing the side yard, and this is a picture showing the front yard. So there's a significant improvement in the lawn.
Did you get the name of the daughter?
Her name is Erin Kaziz.
Erin?
Yes, sir. And she said she wasn't going to be here, and I don't see a representative here.
And do you have a recommendation for me, given that there have been attempts at compliance?
Yes, sir, I do.
What is that recommendation?
Based on the testimony and evidence submitted at this hearing, staff respectfully requests the magistrate find the respondents in violation as set forth in the notice of violation and give the respondents until March 17th, 2020 to come into compliance, or a fine be imposed in the amount of $100 for the first day and $50 every day thereafter until compliance is confirmed by the code enforcement officer, and all costs associated with the enforcement of the violation be imposed.
All right, and let me just confirm, is Erin Kaziz present? Or is anyone else present to give either testimony or to present evidence on behalf of the respondent? Seeing none, no one here, I will go ahead and issue a ruling. I find that the title to the property is listed to Frank and Mary Kiziz, K-I-Z-I-S, 380 Harbor Drive, Cape Canaveral, Florida, 32920. But that Mr. Kiziz is deceased, and that his daughter, Erin Kiziz, is now residing on the property and has been making efforts to bring the property into compliance.
If I could interject, sir?
Yes.
She's not living on the property.
She is not.
She lives out of state. The property is no longer occupied at this time.
Oh, it is, okay. Thank you very much for correcting me. So then I will find that Erin Kiziz appears to be administering the property, although she's not living there.
Yes, sir.
Okay. Do we know where she's living?
I have it written down on my desk. I believe it's Virginia or somewhere up north.
Okay. Then we're going to find that the property is currently unoccupied. I find that there was a motor vehicle with an expired license plate parked on the driveway, also with a flat tire, that motor vehicle was inoperable. That between October 5th and October 20th, 2019, that there was no change in the location of that motor vehicle. I find that the soffit by the front door was seen falling down, just continued in a state of falling down. And also, up until recently, the yard was unkempt, and that the weeds and grasses were growing at over 6 inches in height in violation of the code. And if I didn't mention it before, I find that the license plate on that motor vehicle had expired on April of 2019. I find that the subject property was served with a notice of violation via posting on the property on November 26, 2019, and that the notice of violation was also posted at City Hall, that there were attempts at service via certified mail which were returned unclaimed, but that the service that was provided does comply with Section 2-53 of the City Code and Florida Statutes Sections 162.06 and 162.12. We also find that, as a matter of fact, that there have been substantial efforts to bring the property into compliance, that the yard has now, as of today, has been mowed, the bushes have been trimmed. We also find that an application for a permit has been submitted to the city to replace the roof. However, as of today, no permit application has been received to repair the soffit, which is falling down by the front door. Therefore, I'm finding that the city has established that there were multiple violations on this property, that there was a violation of Section 34-96B of the City Code, which states that every owner of every single-family dwelling or his appointed agent shall keep the property and shall maintain the exterior of the property in a clean, sanitary, and safe condition, that all parts thereof shall be maintained in good repair and shall be capable of performing the function for which such structure or part of any feature thereof was designed or intended to be used, and this speaks directly to the soffit, which is falling down. I find that there was a violation of Section 34-96D of the City Code, which states that the exterior property areas of all premises shall be kept free of all nuisances, litter, rubbish, debris, objects, materials, or conditions which may create a health or fire hazard. Exterior property areas shall be free of unsanitary conditions which constitute a blighting or deteriorating influence on the neighborhood. Lawns, landscaping, driveways, and fences shall be maintained so as not to constitute a blighting or deteriorating effect. I find that this violation had occurred, but was corrected in time for this hearing. I find that there was a violation, that there continues actually to be a violation of 34-98 subparagraph 4 of the city code, which talks about the requirement to present a neat appearance for buildings that deteriorated, worn, or damaged portions should be rebuilt or replaced. And this speaks directly to the soffit, which has not been repaired. I find that there was a violation of 34-121 of the city code, which states that the presence of weeds, brush, and rank vegetation on all properties in the city are a menace to the public safety, health, and welfare as they cause a fire hazard, furnish cover for prowlers, obstruct visibility, furnish a potential harborage or breeding place for disease-carrying insects, arthropods, animals, and poisonous snakes, and may adversely affect and impair the economic welfare of adjacent property. I find there was a violation, but that it has been corrected in time for this hearing. Similarly, I find that there was a violation of section 34-122 of the city code, which states that all grass areas and yards on improved property shall be properly maintained in a neat and attractive manner and kept free of dead plants, refuse, debris, and shall be maintained further in a manner such that grass, weeds, and rank vegetation shall not exceed 6 inches in height. I find that this violation was corrected in time for this hearing. Finally, I find that there was a violation of section 34-181 of the city code, which states that no person shall park, store, leave, or permit the storing or leaving of any abandoned property or inoperable motor vehicle of any kind, whether attended to or not, upon any private property within the city, except that with respect to an inoperable motor vehicle, such vehicle may be parked, stored, or left on the property for a period of time not to exceed 72 hours. The presence of such abandoned property and inoperable vehicles or parts thereof is declared a public nuisance, which may be abated in accordance with the provisions of this article. I find that this violation has been corrected in time for this hearing, but that it did in fact exist owing to the fact that the license plate was expired and there was a flat tire. The vehicle was inoperable in a lawful manner. And so I'm going to issue the following order that the respondents have until March 17, 2020, in which to correct the violations of the city code on the subject property, and that the failure to do so would subject them to a violation, to a fine of $100 per day for the first day and $50 thereafter, plus the costs incurred by the city, and that the respondents are instructed to contact the city community development department to apply for a permit to correct the broken soffit and to take steps to correct that hazardous condition as soon as possible. I find that the damaged soffit is a threat to public health and safety and welfare. If the respondents fail to correct the violations within the time period set forth this evening, that I would ask the code enforcement officer to please schedule a compliance hearing before me and to provide due notice to the respondents and to the daughter, Aaron Kizis, specifically, and to give the respondents an opportunity to appear and present testimony and evidence as to whether the violation is continuing on the subject property. And that the respondents have the responsibility of providing notice to the City Code Enforcement Division of the Community Development Department that they have corrected and have taken steps to correct the violations, specifically with reference to the damaged soffit. If you have confirmation that the violation is corrected, I would ask for an affidavit of compliance. And if not, I would ask for you to notify the city clerk for code enforcement proceedings to schedule the matter for the next available hearing before me. And I would state for the record, as I've stated earlier this evening, that any fines which may be imposed become a lien on the subject property as well as upon other real or personal property of the violators in favor of the city. And seeing that no one is currently residing at this house, and I don't know if it is considered homestead for Mrs. Kizis or not, but if it is not homestead, the property could be subject to foreclosure pursuant to Florida Statutes 162.09, in which case the city could obtain an award of its costs, including reasonable attorney's fees. Is there anything else this evening?
No, sir.
In that case, we'll call the meeting concluded. Thank you.